Good morning, good afternoon, good evening. Welcome to the Law Vlog, episode 13. So this morning, or in today's vlog, we are going to focus on litigation again. I'm going to describe the process of what's involved in how you take a case from first instructions to your solicitor, with your solicitor, for the person in the assessment board, how you go through the circuit high court, and how you ultimately get a judgment or award or compensation in your favour.
The first element of taking a claim is that you must meet with a solicitor. You sit down with the solicitor, and the solicitor will then what's called taking attendance, and they will make a decision and a view on whether you have what's called a statable case, whether that the information you give the solicitor is genuine, that you have been involved in a genuine accident, and at the injuries sustained were caused by someone else, and that someone else there was a breach of a duty or a standard of care, and that liability lies on another person, and that there was a breach of negligence. So when the solicitor is happy that they have met you and they've taken proper attendance, they will then decide to take on your case and go through the costs. So I actually did a whole vlog previously on the costs involved in taking a case, so this vlog is just going to concentrate on the process of taking a legal.
The injuries board then contacts their side, the respondent, who will cause the accident or injuries, and they must then consent to the process. They will usually pass it on to the insurance company will pay a fee, and then the injuries board have 9 months to assess. So the first part of the process is the solicitor will lodge your application with the person's assessment board. The application has two parts. One is the Form A, which is the details of the accident, your own details, a brief description of what happened, who you allege caused the accident, and along with that is it's supported by what's called the Form B, which is the medical report to support your injuries. This application must be lodged within 2 years of the accident or 2 years of first sign of injury. So if both parties or either one party has rejected the PIAB assessment, and the claim must then proceed through the court's process, whether that's circuit court or high court, and that's done by the jurisdiction of the court. The first process, a part of the process is we would send what's called a brief to a barrister. This would be a specialist person injury barrister who would then draft the first legal document, which is known as the civil summons. Once we're all happy with the content of the civil summons, we send it to the court's offices where stamp duty must be paid, and then the summons then is served on the respondent or the defendant in this matter. If one of the parties rejects the injuries board assessment, then we must proceed to court. The injuries board will assess most types of claims. They will not assess medical negligence claims, and historically they did not assess any injuries which of psychological or psychiatric illness. However, since the new guidelines came in April of this year, they're now actually starting to assess some claims which do involve some kind of psychiatric illness. So once the other side have lodged their appearance, they are then allowed to raise questions on the summons. These questions are known as particulars. So they would send what's called a notice for particulars from the defendant's solicitors to the plaintiff's solicitors. This notice for particulars would then be replied by the plaintiff and the plaintiff's solicitors, known as reply to particulars. They would be sent back within a time frame to the defendant's solicitors. The defendant's solicitors can then review these answers. They are entitled to raise further questions or further particulars, which then the plaintiff's solicitor must also reply to. Once the second set of replies have gone back, the plaintiff's solicitor can then request a defence within 28. The defence is a very important document because that obviously sets out the defendant's case, or the defence of the defendant's case, but also it's the last document in the pleadings, pleadings, part of the legal process. Once the defence is received, we would then send the brief to a barrister, back to the same barrister again for what's called an advice on proofs. If it's a circuit court, the junior counsel barrister would advise, and that's really a checklist of what we need to complete to have the case ready for court. And if it's a high court, we would then send the file to a senior counsel barrister for them to prepare their advice on proofs. Also throughout this process, the defendant's solicitors may request the plaintiff to make themselves available for independent medical exam. They may also need to go to some consultant or expert specialist medical exam, which the plaintiff will make themselves available for. Once the advice on proofs is complete, we would then serve a notice for trial, which means that we're applying to the court's office for the next available hearing date. Obviously there's somewhat of a backlog at the moment, and generally there's a 12 to 18 months waiting list from the time you serve your notice of trial from the time your case actually gets heard in front of a judge. Once then your hearing date comes around, you'll be prepared and go to court
on that morning. Court generally starts at 10:30. There's a process in the morning, what's called a call over, where they go through all the list of cases to be heard that morning. Some of these cases might be adjourned, they might be settled, they might be struck out. And then say if you, that morning you might be start off with number 12 on the list. Once the call over starts at 10:30 and finishes, quarter to 10 to 11, you may actually end up being number 4 on the list. So you will know then if you're going to be heard that day. You'll be prepared. If, as I said, if it's a circuit court, you have your junior counsel barrister and your solicitor, and if it's a high court, you have your senior counsel barrister, which is a solicitor of at least, or barrister of at least 20 years experience, and sometimes you would have a second senior counsel in a high court case also. So once then the actual hearing itself takes place, we will call any expert witnesses, whether it's medical, an engineer, eyewitnesses, the plaintiffs themselves will give evidence, and obviously the other side are entitled to cross-examine and bring forward their own witnesses, and then the judge will obviously give judgment. Once the judge makes the decision, you can of course appeal this decision, and there's certain time frames for each court within which to lodge your appeal. So that's it. That's the process to take a claim in Ireland through the Injuries Board, Circuit Court and High Court. The costs then follow the event. So if a judge awards compensation, which is called general damages, they would also, if you're successful, award special damages, which is a refund of your loss of earnings, out-of-pocket expenses, receipts, all that kind of stuff. And then costs follow the event, which means if you're successful, the other side would pay your legal costs on top of any award. That's it. That's today's vlog. Thank you so much for watching. I hope it's been somewhat helpful. I hope you have a great week, and I'll see you again next week.